The time is flying by, and this is already the second to last presentation of our 2025 Business Immigration Summit, if you can believe it. And we have with us an outstanding guest to help us navigate the evolving landscape of the EB-5 visa. The EB-5 program has always been a hot topic, but recent political developments have made it even more critical to stay informed. With discussions about a potential new gold card program and uncertainty surrounding EB-5's future, it's more important than ever to understand the opportunities and challenges ahead. To guide us through these crucial topics, we're fortunate to have Carolyn Lee with us. Carolyn is a nationally recognized leader in investment immigration and the driving force behind her law office of Carolyn Lee. With over 15 years of experience, she has played a pivotal role in mobilizing more than $2.5 billion in EB-5 capital, helping regional centers, developers, and investors succeed in this complex process. But her expertise goes far beyond numbers. As a four-term chair of the American Immigration Lawyers Association National EB-5 Committee and current legislative counsel for Invest in the USA, Carolyn has been at the forefront of EB-5 policy and legislative advocacy. She was instrumental in shaping the 2022 EB-5 Reform and Integrity Act and continues to be a leading voice in the industry. So today, Carolyn will be helping break down the latest EB-5 updates, discussing the outlook for the program, the gold card, and sharing success strategies to navigate these uncertain times. Please join me in giving a warm welcome to Carolyn. Thank you so much, Carolyn. The stage is yours.
Joshua, thank you so much for that incredible introduction. And I'm going to have to invite you to dinner so you can talk me up to my kids. Well, thank you so much to Joorney and to colleagues there for this warm welcome and for inviting me. EB-5 is indeed, it's a fascinating area of immigration law. It's this intersection of so many different things. It's got all of the human drama that all of us immigration practitioners are living with every day with our clients and their hopes and dreams. And then it's sort of supercharged with all of this additional stuff. It's high stakes for both the projects, the regional centers, the underlying fund users, the developers, and for our investor clients who are putting so much of their life-earned wealth into this as well, with at risk, the investments requiring to be at risk by design, by law. So you have to have a strong stomach for all of this, as I've said, and but it is also incredibly rewarding for its challenges. So I'm delighted to be speaking about it today. I'm not quite sure how this format works in terms of allowing for questions from the audience throughout the presentation, but I do welcome it. And if I see questions coming up, I'm happy to pause, and I'll also try to leave room at the end for questions also. In terms of the latest updates in EB-5, of course, we've got to touch on the gold card. So around February 25th, 26th, the president, in the middle of a press conference, mentioned that there's a new benefit in the horizon, the gold card. And the gold card would be distinct from the plain old green card in that it would have a lot of enhanced benefits for the $5 million price tag. And the president did not mention EB-5 at all, but in that same press conference, the Secretary of Commerce did, and he mentioned that the gold card would replace the EB-5 green card. And so this caused a lot of concern among the EB-5 stakeholder community. I mean, what could that mean? How would that work? The next day, there was a second press conference at the cabinet meeting and convened by the president. And the gold card was asked about, and the president again addressed this idea and said that this would be a fantastic thing. It's going to be used to reduce our deficit, And it was envisioned that companies like Apple would be able to purchase these cards for their top talent and enable them to stay. Um, and in this press conference, the Secretary of Commerce said, rather than replacing the EB-5 green card, that it would modify. It was a more modest kind of dialing down of the idea in terms of its interaction with the EB-5. It would modify the EB-5. And so, this made international news, and the questions within the EB-5 stakeholder community was around, is this real? How is this going to impact EB-5? And in particular, investors who have already invested in the program. And the answer is, we don't know, because as far as we know, and as of yesterday, there was nothing written, made publicly available that we could study as a concrete proposal and how it would fit within the existing framework, or where it would come in. It was mentioned during the two press conferences I mentioned that this benefit would be administered under the Commerce Department as opposed to the Homeland Security Department, which is where EB-5 program is currently administered under the auspices of the U.S. Citizenship and Immigration Services. So the framework and how it would be administered, and indeed its interaction, if any, with EB-5 remain to be revealed. The Secretary of Commerce spoke recently at a press conference about 4 days ago, at an interview about 4 days ago or so, where he mentioned that this would be rolled out within about 2 weeks, which would place the date now at around April 6th. So we'll see. He said during the interview that 1,000 had already been sold, and so it seems like there's perhaps a lot more to be said on this, and more to come. So we're staying very much attuned to what's happening on this news channel, and we'll report out on certainly on our firm's various communications channels, and I'm sure everybody will be hearing more about it. So that's that on the gold card. In terms of other news, of course, we've got to touch on the 2.5 year visa retrogression reported in the April Visa Bulletin for the unreserved visa category in EB-5. EB-5, of course, is an employment-based preference visa category, and unlike the other four, our preference category has 4 subcategories housed within it. And these are 4 subcategories that have been created under the EB-5 Reform and Integrity Act of 2022, or the RIA. And these 4 categories are unreserved, and then the 3 remaining categories are nested under the reserved category of or also called set-aside. So you'll hear us talk about set-asides a lot. And those 3 categories in the set-aside or the reserved side of the equation are rural, high unemployment area, and infrastructure. So under the pre-RIA landscape, we had projects in targeted employment areas and everywhere else. And projects in targeted employment areas were at the $500,000 investment level, and everywhere else was at $1 million. So that framework is still the same. We've got a lower investment threshold and a higher investment threshold, and they're just mapped to slightly different definitions. We've got set-asides where the lower investment thresholds would apply, where investments made into rural area projects, high unemployment area projects, and infrastructure projects would be set at the lower threshold, now increased to $800,000, and everywhere else is unreserved. Those other visa petitions would go into the unreserved category. And the unreserved category has all of the pre-RIA cases. So all of the TEA cases from the pre-RIA world, as well as investments post-RIA that don't fit the set-aside criteria. And so in the unreserved, currently everything is current. There's visa availability in the set-aside categories of rural, high unemployment area, and infrastructure. And we had a cutoff. We've had a backlog in the unreserved side of things. And we had a cutoff of July 2016 for China and January 2019 for India. And those cutoff dates had been very static for some time until the April visa bulletin came out, reporting a 2+ year retrogression in both those, for both China and India-born investors. Rest of world remained current. And I happened to have been in China the day that the visa retrogression was announced, that the April visa bulletin came out. And I literally woke up to this news, which caused a shockwave in the entire EB-5 community there. And it was tremendously upsetting. In one of the meetings I attended, there was actually a lady whose priority date was literally a week behind the March priority date cutoff. Her priority date was like July 20th of 2016 and had been July 15 of 2016. And now she was retrogressed over 2.5 years. So this was very, very upsetting. And the questions were questions that that everyone might have, which included, how did this happen? What does this mean? Why did it happen? Could it retrogress further? Will it advance? When will it advance? And so to try to tackle these questions, we can look at what the State Department itself provided as explanation in the April visa bulletin. And the State Department said, well, it's due to increasing demand and numbers usage by China mainland-born investors, India-born investors, and rest of world. And so what could this mean? Increased demand and numbers usage. So it means that USCIS is clipping through the approving pre-RIA petitions at a faster rate than the State Department had anticipated. And that the applicants are presenting themselves as documentarily qualified and ready for visa issuance, and that the consulates are efficiently issuing these visas across the world, in China, in India, and the rest of the world. And so the confluence of these facts beyond the State Department's expectations have resulted in these cutoff dates retrogressing. Moreover, the State Department said that the increased demand and numbers usage in the rest of world, in the unreserved category, might mean that we would have to establish a cutoff date, a cutoff date in the rest of world and unreserved as well. And kind of reading into what that could mean and how that plays into this phenomenon, I think what is partially behind this also is an unexpected surge in demand in the rest of world, because there is a relatively high number of visa applicants in the rest of world backlog in the unreserved category. And for the figures that I'm about to share with you, I'm going to give a shout out to my dear friend Suzanne Lizicki and the data that she publishes on her blog, lucid business writing. Please support her work. She's amazing. And what we see is that we've got a backlog in the unreserved category of about 46,000 visa applicants, including investors and family members. But we only have, in a normal year, 6,800. That's just by, operation of normal numerical limits. This particular year, in fiscal 2025, we have a lot more than that. We have about 11,500 by operation of the carryovers in the RIA. But still, you compare that to the backlog of about 46,000, there just are not enough numbers in that category for the applicants in queue. And then breaking that down, just for your for context, there are 33,000 China-born visa applicants, about 3,600 India-born visa applicants, and about 9,300 or 9,600 rest of world visa applicants. So you can see how, we talk a lot about China and India backlogs and investors, but we don't really talk about the rest of world too much. But you can see how big that number is, relative to the other categories. It's like nearly triple the number of Indian-born investors in the unreserved category. So, and there's no cutoff at all right now in the rest of world. So as that demand presents itself, the visa office has to meet that demand. And so if that demand surges, those numbers have to be allocated, and that reduces the number available to the backlogged countries with cutoffs, China and India. So, what you've just heard is a combination of what the State Department reported and my own gloss. And so, and then, in terms of the other questions, they're going to are we going to see further retrogression, and when will we revert back to 2016 and 2019, the March priority date cutoffs or final action dates? Very, very difficult. I mean, that now we're getting into speculation and crystal ball gazing, and I can't say, I don't have anything reliable to base any prognostications on. My own guess, and this would only be guesswork, would be that the priority dates probably will not further retrogress, although anything is possible, anything can happen, obviously, because I think, it would be rational for the visa office, seeing this surge, unexpected surge in the demand and usage, to kind of hold up, to establish a final action date that's safe, as safe as possible as far as they can see, from further retrogression. And, holding to those quite early priority dates is, probably a safe, those are probably safe demarcations, because those dates are pretty early. And I would imagine that there aren't that many visa applicants who with priority dates earlier than those cutoffs. And so, holding the demand steady there, and then allowing the demand and the rest of the world to be satisfied. So that's it on the visa retrogression for April. The other categories, the set-aside categories that are really driving the growth and the usage in the EB-5 world post-RIA, those numbers are still current, although, of course, we're very, very closely monitoring the visa bulletin for cutoffs in the set-asides as well, because in January of this year, the State Department reported in the visa bulletin that we may see cutoffs in fiscal 2025 in the set-aside categories as well. And so, that means that we won't be able to concurrently file adjustment of status applications for EB-5 investors who are mainland-born China and or India-born, because we would only be able to do that if there were visa availability. So that's the news that's fit to print on the visa retrogression front reported in the April Visa Bulletin. I think it's also worthwhile to talk a little bit about the sustainment litigation. So what this is about is the length of the sustainment period, how long EB-5 investors are required to maintain their investment in the EB-5 project. Now, this is separate and not to be confused with the underlying deal term of that particular EB-5 project under consideration, or generally EB-5 projects, because we're going to have those deal terms. Typically, in loan-based projects, things can be more open-ended where the model is more of an equity investment without a maturity. But typically, you're going to have a new commercial enterprise where the pooling of the investment is happening, where the EB-5 investors are making their direct investment into in exchange for a membership interest or partnership interest in that new commercial enterprise. The new commercial enterprise pools the investors' funds, and it may make a loan to the underlying borrower, which is then going to be the ultimate end user of that capital and be the job creating entity, use that capital for job creation. And that loan term is going to have a duration, a period. In, it could be 5 + 1 + 1, it could be 4 + 1, or 4 + 1 + 1, or 2 + 1 + 1 + 1. That varies. So that it's going to have a deal term, and so that is separate from the immigration requirement that we're talking about of how long is an EB-5 investor required to maintain or sustain her investment in that new commercial enterprise. And there was an open question about that until 2017, when USCIS published its policy on redeployment and sustainment, and it said, the sustainment period is 2 years of conditional residency. So it's at the back end, got to keep the capital in the new commercial enterprise until the end of that sustainment period, 2 years of conditional residency. If the business term is allows for the capital to return to the new commercial enterprise earlier than an investor sustainment period, because it had a 5-year term or 5 plus whatever it was, but the investor who was in a backlog was not yet ready to be redeemed because the immigration process was still ongoing, well, that capital would have to be redeployed under the USCIS policy. Okay. Now, that was the pre-RIA sustainment policy. And the RIA was enacted in March of 2022. In October of 2023, USCIS published its interpretation or policy with respect to the sustainment period. And interpreting the changes in the RIA, the service said now the investment is a minimum of 2 years, And so this shifts the sustainment period to the front end rather than to the back end of the immigration process. So there are other conditions that had to be satisfied, like there had to be the full investment, not merely partial, and so forth. But it was 2 years of investment at minimum. It could be longer. So that if the deal were, whatever, 4 + 1 + 1 or 5 + 1, that it didn't interfere with that, but it had to be a minimum. It could be a minimum, had to be a minimum of 2. And this made investors, of course, happy because yes, the immigration can take however long it did, but they would have their capital back if the projects, deal terms lined up with this investment policy, USCIS sustainment policy. In March of 2024, IIUSA sued USCIS based on this policy interpretation of the RIA. And among other things, its sole legal challenge was that this policy was promulgated when formal APA notice and comment rulemaking should have been engaged instead. The judge ordered the parties to enter into settlement discussions, and the parties are engaging in these negotiations right now. And there have been 2 joint settlement reports presented to the court in pursuant to all of that. And the second one was just released a couple of days ago. And in it, essentially, the negotiations have been about rulemaking and the timing of it, essentially. And with IIUSA saying, hey, you engage in formal rulemaking, and we want you to do this on an expedited basis. With the service pushing back and saying, we certainly can't expedite because operationally that doesn't work. And the administration, this is new for the new administration, and it's got to study all of this before it takes any action. The second joint status report reporting that the service will agree to a November 2025 timeframe for starting the rulemaking process. But not committing to when the final rules will be put into effect. So that's the status on the sustainment litigation. If there are any questions on that, I'm happy to pause and take some questions on any of those developments. Or if our host wants to ask any questions, please feel free.
All right. Thank you so much, Carolyn. We definitely have a few questions here, and if anybody else would like to ask anything, feel free to add it to the Q&A in the time we have remaining. So, of course, hot topic, first thing you mentioned, we certainly have a few questions about the gold card.
Bring it.
First question, would the president have the power to create this new visa category without congressional approval?
Within the INA, no. Yes, the Immigration Nationality Act is an act of Congress, of course. And so any amendments to the INA would have to come from Congress.
Absolutely. Absolutely. So we think not, but strange times and strange things can sometimes happen, right?
Yes, indeed.
Yes, indeed.
I mean, I'm interested, right? My curiosity is piqued. Certainly within the framework of the Immigration Nationality Act, the RIA itself is a part of the INA. So to amend the INA, to amend the RIA, that would have to come from Congress. But, perhaps it can be nested by agency action somehow, which would be, I think, in terms of addressing the concern of, could this affect EB-5? I think, that could be great, have this alongside, be creatively architected outside the framework of the INA, and that would insulate EB-5 to, continue to do its thing.
And that was going to be my follow-up question, assuming the gold card does come into play, as we may find out on April 6th or later, to be determined. How would you like to see the gold card and the current EB-5 system potentially interplay together? Would you foresee, it sounds like no, the gold card replacing the EB-5, both options available? What would be the perfect situation in your mind?
I think a healthy ecosystem and of any kind, any system, is complexity and variation and variance. So I personally would welcome seeing it. And I mean, I think reducing debt is fantastic. And I'm also curious to see whether there is, the extent of the world demand for that benefit. Um, as an EB-5 advocate, I would not want to see a program that upends EB-5, certainly in any kind of, you know, um, anything that would disturb the interests in particular of investors who are already in. Anything retroactive
Mhm.
would, I think, raise some serious due process concerns. But, alongside it, I think could be very interesting and could be possibly wonderful.
Speaking of not affecting the people that are already in, we have another question. Are you seeing an increase and a spike in EB-5 applications following that gold card announcement of people who want to get in as soon as possible?
Yes, and certainly, like heightened interest and heightened anxiety.
Mm,
And I am very personally, I don't think those two are good combo, are good together. This is, as I said from the very beginning, this is a weighty undertaking. It's your hopes and dreams, your family, often you're doing it for your kids. It's a lot of money. It's a lot of waiting. It's a lot of uncertainty. And when you're undertaking a decision like this, you want to make sure that this is the right decision for you and your family. And so there are, ideal conditions for making this kind of a decision. And it shouldn't be under anxiety. It shouldn't be based on fear.
yeah,
Um,
absolutely.
so so if, um, uh, we should make these decisions with the best information possible, calmly, and knowing that with the information we have, this is the best decision forward. What is real is the potential looming backlog, right? When we start to have final action dates, we will not be able to concurrently file adjustment of status, which is a game-changing, huge, real benefit that our clients and investors have. They've got work and travel authorization, independent of everything else. And that, there's a cutoff to that. So I think that's real. That should, be a real consideration in driving decision making.
Absolutely. Absolutely. So if somebody
Yeah.
comes to you with an EB-5 project nowadays, are you trying to, obviously without increasing anxiety and taking the sufficient amount of time to prepare everything correctly, are you advising them, let's do it sooner than later, let's wait and see? Any thoughts about that?
I really, really trust the client. And often, especially because we're like in this sort of soup of the unknown. Often the clients will want to hear, what should I do? And maybe our colleagues, what should we do? What should we advise our clients? And I think that, I see my job as delivering the best information I can to feed the decision making. And then I really trust the client. And every family situation is different, and
Sure.
their goals are different. So if I do my job as I see it, of delivering that high quality, you know, um, information, then they will make the decision that's best for them.
One last gold card related question before we move on to some other topics. And this is an interesting one. Do you know if there's actually any confirmation that 1,000 gold cards were sold, or is that just speculation on behalf of what they announced?
I have no idea.
Okay. Okay. So no proof that we know at the moment. Um, Couple other questions here on some different topics. Do you have any suggestions regarding the use of loans or gifts as a source of funds? And then specifically, it seems that after Zhang versus USCIS, it's no longer necessary to prove that a loan is secured by collateral.
All true.
Okay.
Yes, yes. Um, I am, careful about that. I think, first of all, I think it's prudent to have that careful, cautious approach with source of funds generally. Take nothing for granted. There is no easy kind of case, right? And I feel especially that way with unsecured loans. They are permissible. However, they've got to be bona fide, absolutely bona fide, documented as such. There's got to be loan documentation and also proof that they're, bona fide loans beyond what is submitted with the initial petition. So we generally advise clients to make sure that they're actually servicing the loan pursuant to the actual written formal terms of the loan agreement. Treat it as an arm's length, treat it as if the lender is Bank of America, giving you an unsecured loan, and retain proof of all of that.
And then another question here about source of funds. If there's anything else we can add, um, they ask, can you analyze the impact of the recent EB-5 path of funds case law for their source of funds memo as a whole? Should we still need to be conservative?
Always the answer is yes. Yes, be super conservative. We almost can't be conservative enough. Um, I think it's like Ben and any. It's favorable to us generally in that it's reaffirming that there is a limiting principle to agency scrutiny in the source and path of funds. It isn't indefinite. We don't have to source the funds and go back to the time when somebody earned a salary literally in salt or seashells or something. There's a limit. We don't exactly know where the limit is with respect to bet in any, I think, because of the sort of internal um, contradictions almost within that decision. With respect to the Pathofunds decision, Zhu, I think we have a little more clarity, which is helpful, which is we look to the petitioner and it's the petitioner's lawful source of funds and path of funds that we look to, not to, a party beyond the petitioner. But that case was also remanded, as was Bet in any. And I'm holding my breath and seeing how those cases fare on remand.
Amazing. Thank you. And shifting from source of funds, Jessica asks, can you buy a business with one LLC and then buy the building for that business with another LLC and use the two LLCs to get one standalone EB-5?
Wow, now I feel like USCIS. I do not answer case-specific questions, and I can't because I'm not rendering advice. But I can speak to the new commercial enterprise and holding company structure. So it is permitted under the definition of the new commercial enterprise under the RIA for the new commercial enterprise to be a holding company. And so as a holding company, it can have wholly owned subsidiaries. And the job creation activity can take place at the subsidiary level, and the jobs can be attributed up to the new commercial enterprise. So hopefully that helps.
Great, great. And another question is asking if you have any opinion about the challenge of USCIS's interpretation of the sustainment period.
You mean like the services position in that litigation?
Yeah, that would make sense.
Okay. I I think the services position is it makes sense. Um, we know how the agency works. I, you know, could it engage in expedited rulemaking? I think as a legal matter, I'm not sure on this. I think this is an APA question. I think they probably could. operationally, I mean, we just know from our observations of the advance notice of proposed rulemaking and the notice of proposed rulemaking process that rulemaking takes a while. I think the last ANPRM was in 2016 or 2017, right? NPRM around that time, and it took a couple of years for EB-5 rules to be actually published. So in the normal course of things, it takes a while. I also found the position stated in the second joint settlement report pretty well thought out, actually. It stated principles like, that operationally it's difficult for us to commit to expedited rulemaking, and they also said we also can't, that it sounded like the plaintiff was asking for, sort of prospective standards that would apply to investors right now. And that doesn't square with the principle that cases have to establish eligibility at the time of filing. And how could petitioners do that keyed to prospective standards? I mean, right? So logically, that holds. So I think its position is well stated.
Amazing. Thank you. And then we have a couple more questions here about maybe some issues that pop up and delays. So this is a specific case, but then a more general question. The question is, there's a client whose I-526E has been pending for almost 2 years. Hard to get information about that. Do you have any tips as to, if you know of reasons for these type of delays, how to check those status or expedite those getting pushed forward? Anything on that end that you could recommend?
Yeah, I'm guessing this is a high unemployment area case, for which 2 years of pendency is not beyond the pale. And, with the service reporting very lengthy published processing times, that's limiting, and then the decisions that we have in district courts on mandamuses and 526s, it's not going our way either. So it is difficult. That said, we do have the email box, which is unique in the service, the product lines that the service administers. So, if there's a good reason to use that box, if there's any error, if you think that, for example, Case Status Online reports there's an RFE issued, but no one's gotten an RFE, that certainly would be a very good reason to send an email to IPO.
Perfect. And that's a great transition into the final question I believe that we have, which asks about RFEs. Your comments on some of the more common RFEs you might be seeing these days, perhaps denials, how to attack those, any RFE specific ideas or strategies that you can share with us.
I think what we're seeing in these RFEs is a tighter, closer scrutiny of the source of funds. And moreover, I think it's fair to report as a trend, although not very widespread yet, thankfully, that the source of funds questions can survive into the 829, which is really kind of a nightmarish thing to think about because, at the 829 stage, especially with backlogs coming, we could be looking at the case again a decade after filing. And when you're being asked about source of funds a decade after filing, you're going to be asked for things that probably, or may not exist anymore, like bank statements. So, I think that my soundest tip would be to prepare the case with that in mind. And because when there's something, a question or a doubt that gets triggered, there is pretty much, it's open season. The discretion is so broad that the inquiry can go quite deep and also, be spread out. And so the best course of action is to try to avoid that. And you do that by presenting a credible case that is solid and makes sense every step of the way. I think that's truly the best advice. Trying to think of also some more specifics. Um, Employment, prior employment. Often the source of funds is traceable ultimately to somebody having earned employment income at some point up the chain. If it's a student's grandparent who acquired ancestral property generations ago, yes, you're not going to be able to point to tax returns or bank statements or like maybe even a deed, but that has to be explained. And that notwithstanding some of the favorable decisions that we've talked about here on source of funds and path of funds. And I think that goes to, you know, um, we want to address the sort of the natural kind of questions that we imagine an examiner would ask. Where did this come from? It didn't come from poof. Where did it come from? How was it acquired? Even if there isn't like, 2 inches of documentary proof to support that, you do want to put that in a narrative by the best person. If the grandparent is still alive, getting a statement from the grandparent, it's firsthand source, it's direct evidence. If the grandparent is no longer with us, then, a statement from the parent that, details the facts as much as possible. And the more detail that we have, the better, because A, it's more credible, and B, it paints the picture. And the examiner is a human being. Or I should say, I mean, we are also learning that there's potentially artificial intelligence being folded into adjudications. I'm not surprised, but then let us say that a credible narrative is about being able to picture these facts, and the more flesh you can put, the more color you can put into the canvas, the more persuasive it is. Takes
And
more effort, but I think it's worth it, particularly to ward off the 829 RFE.
and as you mentioned, with AI potentially sneaking into some of these reviews, will that change your strategy and how you file anything or word anything, or business as usual?
No, no. I mean, when you put the question that way, maybe we're hearing of, there are ways to sort of game the potential AI. Um, that isn't our approach. Our approach is to be, good faith purveyors of the actual facts. And I do believe that, if we do that, you could still get an RFE, but we should be able to overcome that. And if we can't overcome that with good faith facts, then there's an issue at the agency side.
Perfect, perfect. That's an amazing statement to wrap up our session as we have a few minutes before we jump into the next one. Carolyn, we want to thank you so much for all the fantastic information and updating us on EB-5. A couple people did jump in at the last second with looks like some case specific type questions. And please remember, you can reach out to Carolyn. We provided her information into the chat box. We're so happy that you could join us today. Carolyn, please let us know if you have any parting thoughts on our way out.
Well, thank you again. This was really fun. And I appreciate the great questions. Good luck,
Amazing.
everybody.